All right, and we are recording. Hello, everyone. My name is Jeff Wakeman. I am the Director of Student Development at Stockton University. And tonight we are gathering together to talk about free speech and the First Amendment and the freedoms that we have on college campuses and really anywhere in the United States, or just about anywhere. We'll get to that in a minute. I would like to take a moment and introduce our speaker, but before that, I'm going to mention that this is on YouTube. We are recording, so if you have a question or answer and your question for our speaker, please use the Q&A function on your Zoom call there. We will be answering those, and I won't be saying anybody's name. If you are okay being on the YouTube recording for later, if you use your raise the hand function at the end of the discussion, we will be able to take some live questions also. So I want to really quickly get to our speaker. Our speaker tonight is Nico Perrino, who is the Vice President. I'm reading this right off of his website. The Vice President of FIRE, which is the Foundation for Individual Rights in Education. Vice President of Communications. He is also the host of the So to Speak podcast, which I'm a listener to and a podcaster. So that's why I selected Mr. Perrino here tonight. So, and he's going to be talking all about free speech tonight. So I'll turn it over to Nico. Nico, how are you doing tonight?
I'm doing great, Jeff. I just want to confirm before I move forward that everyone can see my presentation and ideally also see me at the same time with the side-by-side view, just so I'm not a disembodied voice.
Sure.
Jeff, does that look good?
Yeah, it looks good to me. If you can't see that, check your view button at the top right corner of your Zoom. If you hit view and side-by-side speaker, should be the best way to see it. But I am getting confirmation in the chat that that's what it looks like to everybody else.
All right, great. Well, Jeff, I appreciate you inviting me to come speak to you and your colleagues and your students today about the First Amendment, and in particular, its free speech provision and how it applies on in high schools, and then I'll focus in particular on college campuses. And then near the end of the conversation, I will go over some of the common free speech issues we see on college campuses before closing with kind of a philosophical review of why free speech is important. Often we think of free speech, some people think of free speech as being important because it's protected by the First Amendment, but that's a circular argument. Why is it protected by the First Amendment in the first place? I work for the Foundation for Individual Rights in Education. We're a nonprofit, nonpartisan organization that defends civil liberties on college campuses. I started working for the organization in 2010 and then came to work full-time in 2012. And aside from 1 year working at another public interest law firm, I have been at FIRE ever since. So FIRE was founded in 1999 by these two gentlemen. The man on the left is Harvey Silverglate. He's a criminal defense attorney based out of Cambridge. He's taught some at Harvard. And the man on the right is a professor, or was a professor. He's now taken emeritus status at the University of Pennsylvania. His name's Alan Charles Kors. He's probably the foremost thinker on the Enlightenment in the United States. He edited the Encyclopedia on the Enlightenment. And back in the mid-90s, they wrote this book, The Shadow University, The Betrayal of Liberty on America's Campuses, which was about the rise in speech codes and free speech, and in particular due process infringements on college campuses. And after they published that book with Simon & Schuster, they were just inundated with requests from faculty members who had seen their academic freedom rights violated and students who had seen their free speech rights violated. Now, both of them being working men with full-time jobs, they didn't have the time to address all of the concerns from their correspondents, so they founded FIRE in 1999 to field all those requests and help students and faculty members with their questions regarding civil liberties on college campuses. Now, FIRE defends a lot of student rights. We defend student press, we defend the right to assemble, to associate, we defend religious liberty, due process, and to a certain extent, privacy rights on campus. But for us, and probably what we're best known for, is our work on free speech, which, as a Supreme Court justice once said, is the indispensable condition of nearly every other form of freedom. Now, the First Amendment has 45 words. It has 5 freedoms within the 45 words. Those freedoms are the freedom of religion, speech, press, assembly and petition. We don't have much petition work on college campuses, but this slide you see right now is from the exterior of the now defunct, sadly, museum in Washington, D.C. It was sold and went out of business earlier this year, I believe, in January, and we don't know where this big block of this big homage to the First Amendment is going any longer, but it's kind of cool that it existed in Washington, D.C. So those are our 5 freedoms, and the title of this presentation, America's First Freedom ? Speaks to a misunderstood idea behind the First Amendment. That people often think that it's the First Amendment to our United States Constitution because it's the most important, but that's not actually true. There were 2 previous amendments that were proposed to the Constitution that didn't get ratified. The first of these would have established how members of the House of Representatives would be apportioned to the states. And the second of Madison's first 12 amendments would have forbade Congress from giving itself a pay raise. Congress could vote for a pay raise, but it would only apply from the beginning of the next Congress. And that eventually became the 27th and most recent amendment to the United States Constitution in 1992. So it's just kind of a quirk of history, in fact, that the First Amendment became our First Amendment. But in my heart and in my mind, it is the First Amendment because it is the most important amendment. As I mentioned at the top, I want to start by talking about free speech rights in the high school context, because they're slightly different than the context that we have here on college campuses. And the standard for determining free speech rights in the high school context is Tinker versus Des Moines Independent Community School District, a case out of from 1969 that I'm sure many of you are familiar with. It involved 2 students who went to their school wearing black armbands to protest essentially the Vietnam War and the lives lost during that war. And the students were suspended for wearing the armbands, and they eventually enlisted the American Civil Liberties Union, the ACLU, to take their case. And it went all the way up to the Supreme Court, where the Supreme Court held that it can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. A broad kind of sweeping judgment that was probably the high watermark for freedom of expression case law in the high school context. In that case, the court did create a carve out to freedom of expression in the high school context, which has kind of been called the substantial disruption test, which held that speech that materially and substantially interferes with the requirements of appropriate discipline in the operation of the school can be restricted. And in subsequent years, the Supreme Court and many school districts have driven a truck through that hole. The idea being that substantial disruption is kind of a broad and vague term that can be interpreted differently. And in the 3 subsequent cases, Bethel School District v. Frazier, which involved a speech given at that school that featured sexual double entendres, Hazelwood v. Kohlmeyer, which involved the student press, and Morris v. Frederick, which was that famous Bong Hits for Jesus case. They held up a banner as the Olympic torch was going by. The Supreme Court essentially ruled against the students and against the free expression claims being made in those cases, using that substantial disruption clause of the Tinker case, like I said, driving a giant truck through it. So where free speech rights stand in the high school context right now, you obviously have some rights, as Tinker held, but the substantial disruption clause has kind of narrowed some of the interpretations of those rights, or narrowed the scope of those rights somewhat, at least as far as the courts are concerned, since then. But in the high school context, you have in loco parentis, you have students who are not quite adults unless they've turned 18, they're seniors in high school. Once you get to college, the students come in with their kind of full First Amendment rights. And as the court held in Healy v. James in 1972, the vigilant protection of constitutional freedoms is nowhere more vital than in the community of American schools. And this is with good reason. Colleges are our marketplaces of ideas, right? They're where we come to have our most deeply held beliefs challenged. And as we like to say at FIRE, if you spend 4 years in college and never confront new ideas or even are offended by someone else's ideas, you should probably ask for your money back. And, there have been many subsequent cases after Healy v. James, or in addition to Healy v. James, that have held similar protections in the higher education context. There's Papish v. Board of Curators at the University of Missouri, which actually involved a student publication that on the front had police officers raping the Statue of Liberty. And the university tried to censor that publication, and the Supreme Court said, no, you cannot, essentially holding that the mere dissemination of ideas, no matter how offensive to good taste, on a state university campus may not be shut off in the name of conventions of decency alone. There was another case, Sweezy v. New Hampshire, where the Supreme Court held teachers and students must always remain free to inquire, to study, and to evaluate, to gain new maturity and understanding. Otherwise, as they said, our civilization will stagnate and die. Very strong words from the Supreme Court there on the protections to free inquiry that exist on our college campuses. But we should be clear. The First Amendment only applies to the government. Private universities have their free association rights to associate around a shared set of values that do not necessarily have to include freedom of speech. This is why schools like Brigham Young University can create prohibitions on the clothes that you can wear. They have a prohibition on having a beard. Their free association rights allows them to associate around other values aside from freedom of speech. Now, that said, most private colleges understand that in order to attract the best students and the best faculty members, they need to promise freedom of speech and academic freedom. These promises are often explicit, and many courts have actually held them to be contractual obligations that colleges must uphold. For example, I think it was just in the past year, 2 court cases involving private universities, in these cases, Marquette University and Fordham University, had courts rule against the universities when their contractual promises for freedom of speech were violated. And one of those cases in Marquette involved a contractual or a promise of academic freedom, and a faculty member had sued, John McAdams. And at Fordham, it involved a student group, the Students for Justice in Palestine, who had their student group denied recognition based on the viewpoints of that organization. And the court held that the university could not do that at Fordham because it had promised its students groups the right to freely associate and to freedom of speech. So, as I mentioned, many private universities will promise in glowing terms free speech rights, and Yale is one of those. They promise the right to think the unthinkable, discuss the unmentionable, and challenge the unchallengeable. And they go on to say, when you agree to matriculate, you join a community where the provocative, the disturbing, and the unorthodox must be tolerated. When you encounter people who think differently than you, you will be expected to honor their free expression, even when what they have to say seems wrong or offensive to you. Now, for FIRE purposes, we do work on public university campuses and private college campuses. The only standard that we have in determining whether we'll take a case is whether it's protected, that speech is protected by First Amendment standards, either by the First Amendment at public colleges and universities or by First Amendment standards at private universities that promise free expression. So what speech isn't protected? There is a slate of it, which I have up on the slide. There's incitement, which, as the court held in Brandenburg v. Ohio, means speech that is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. So often people will throw around the incitement standard as a catch-all if there's some speech that they want to prohibit, but they forget all the various tests that the courts use to determine whether speech is actually incitement. It must be directed to inciting or producing imminent lawless action and is likely to produce that action. So if it's unlikely to produce that action, it's not incitement. And this goes back to, I believe, a KKK rally where the speaker at this rally said, we're not a revengeant organization, but if our president or our Congress or our Supreme Court continues to suppress the white Caucasian race, it's possible that there might have to be some revengeance taken. Revengeance is not a word. I guess Ku Klux Klan isn't very articulate, but the reason that wasn't held to be incitement was because it wasn't intended to incite imminent lawless action. there might have to be some revengeance taken, that speaker had said. There's also fighting words, which the Supreme Court hasn't really used since its case Chaplinsky v. New Hampshire in 1942, which involved actually a group of Jehovah's Witnesses, or one Jehovah's Witness who was being attacked by an angry mob, essentially. And the Jehovah's Witnesses, unfortunately, had a lot of persecution in the middle part of the century. But the police were called, the police weren't helping this Jehovah's Witness, and he called the police officer a damned racketeer and a damned fascist. And the court held that some words by their very utterance inflict injury or tend to incite immediate breach of the peace, and upheld the conviction of this Jehovah's Witnesses for essentially calling a police officer a racketeer and a fascist. Now, it's widely held in the First Amendment community that if that similar case came up today, it'd be very unlikely to pass that standard. So a lot of people think the fighting word standard is kind of a defunct standard. And then there's the other most common one that you'll hear thrown around is the true threat standard. As the court held in Virginia v. Black, it's when a speaker directs a threat to a person or group or persons with the intent of placing the victim in fear of bodily harm or death. And then there are the other standards, which I won't get into, but there's obscenity, defamation, commercial fraud, and then, of course, child pornography. Now, one of the biggest areas of confusion surrounding free speech and its exceptions is a lot of people think that hate speech is a prohibited form of expression under First Amendment standards, but that's not true. The Supreme Court quite repeatedly has said that hate speech isn't an exception to the First Amendment, because hate speech is a subjective term. It's in the eyes of the beholder and cannot be properly defined. And this has been almost a unanimous viewpoint of the court for 50, 75 years, in fact, and conservative and liberal justice are in widespread agreement on that. However, most students themselves think that the First Amendment prohibits, or I shouldn't say prohibits, has an exception for hate speech. Now, I should say some hate speech can come in the context of the previous types of speech that are not protected by the First Amendment. It could come in the context of incitement or perhaps a true threat. But often the speech that we're seeing labeled as hate speech doesn't fit those other standards and is therefore protected by the First Amendment. We did a survey last year, I want to say, or 2 years ago, where we surveyed 1,400 students, and around half of them didn't know hate speech was protected by the First Amendment. Some cases involving that the court looked at involving hate speech: Texas v. Johnson, which is the famous flag burning case, and then there's the famous Snyder v. Phelps case involving the Westboro Baptist Church and their abhorrent protests outside the funerals of dead service men and women. The Supreme Court held in Snyder v. Phelps, which is a 2011 case, that speech is powerful, can stir people to action, move them to tears of both joy and sorrow, and, as it did here in this case, inflict great pain. On the facts before us, we cannot react to that pain by punishing the speaker. As a nation, we have chosen a different course, the court said, to protect even hurtful speech on public issues to ensure that we do not stifle public debate. That choice requires that we shield Westboro from tort liability for its picketing in this case. So there are broad protections for freedom of speech under the First Amendment, but nevertheless, speech codes exist on public university campuses across our country. So our latest speech codes report that we put out every year, and our new one is going to come out next month, our latest one revealed that 25% of the 471 colleges and universities that we analyze maintain policies that seriously infringe upon the free speech rights of students. So they get what's called a red light rating from FIRE, which is the worst rating. This is over a 4% drop from last year, so we're trending in the right direction nationally. But it is over 50% lower than the percentage of red light schools at institutions that we reviewed in our 2009 report. So overall, the trend is good, but there's still 64% of institutions that earn what's called a yellow light rating. And this rating reflects policies that are not red light policies, but the speech codes themselves restrict expression that is protected under First Amendment standards and invite administrative abuse. So red light is very explicit. These policies clearly violate the First Amendment. Yellow lights are a little bit less restrictive, but still violate First Amendment standards by the nature of their vague and broad drafting. We also have green light institutions, which means these institutions maintain no policies that restrict speech on their face. So a couple of examples of speech codes. Probably one of the most famous ones that we've ever highlighted is one from Drexel University, which said the use of derogatory names, inconsiderate jokes, and inappropriately directed laughter were prohibited. Inappropriately directed laughter being very difficult to restrict, in my opinion. But last year we had a policy that said that students and faculty can never send harassing, annoying, threatening, defamatory, offensive, or fraudulent messages or images to others. The problem with this latter policy being that annoying and offensive are not prohibited under the First Amendment or First Amendment standards, and are very vague and broad codes, or words, I should say, that are subjective in their interpretation, can be applied to a wide swath of protected speech. I should note that when speech codes are challenged in court, they very, very often, I should say 90% of the time, lose. But FIRE doesn't always litigate every case that we get involved in. In fact, we didn't start litigating any cases directly until 2014. How we handle cases is we like to write a letter to the college or university first and try and mediate the dispute privately, unless the dispute is already playing out in the news media and public, in the public. If we can't figure out a solution through the letter, then we will often, or if the college or university doesn't respond to us, we will then take the case public. And oftentimes that works to resolve the issue. If that doesn't happen, there is a consideration of whether we will file a lawsuit. I should note that a lot of people think of FIRE as a legal organization, but we are a multifaceted organization, an educational organization. In addition to a legal organization, we have a high school program, we have a faculty program, we have a student network, we have a lobbying arm that seeks to create civil liberties laws across the country that protect student and faculty rights and also prevent bad laws from going into effect. We also have a communications program where we do a lot of different things to educate the public on civil liberties values. I just created a documentary, for example, a feature-length documentary called Mighty Ira: Civil Liberties Story, which is about the life and career of Ira Glasser, who ran the American Civil Liberties Union from 1978 to 2001 and sits on FIRE's Board of Advisors. And we use Ira's story to explain why freedom of speech is important, because Ira spent a lot of his career defending that value in addition to values of racial justice. And the film seeks to explain how racial justice and freedom of speech are partners, not antagonists, despite what many people in our society argue today. So FIRE is a multifaceted organization, as I said. When we're involved in cases, however, we start with a letter, then we move to publicity before we even consider a lawsuit most of the time. Now, what are some of the examples of censorship that we most often see on campuses? Free speech zones are very common types of cases we see on campuses. 1 in 9 of America's 471 top colleges have misleadingly labeled free speech zones. I call them misleadingly labeled because they are often zones where you have to get prior permission to speak. And at this school, featuring this man, Nicholas Thomas, who was a student at Cal Poly Pomona, he not only needed to get prior permission to speak, he could only speak in the free speech zone. And when he was in the free speech zone, he had to wear a special badge that had signified, like a scarlet letter, that he had gotten prior permission. And you could only use the free speech zone during certain hours and on certain days. And that's unconstitutional. We filed a lawsuit on his behalf and won. Another school that had a free speech zone, a misleadingly labeled one, was Texas Tech. And the thing about their free speech zone is that if every student at Texas Tech wanted to exercise free speech rights at the same time, in order to fit into the free speech zone, they would have needed to be crushed down to the density of uranium-238. University of Cincinnati, another school that had a lawsuit filed against them to challenge their free speech zone, comprised just 0.1% of the campus. So we see these sorts of cases all the time. And actually, there are many states across the country that have passed specific laws to prohibit them. Tennessee is one of them, for example. So in addition to the Constitution's prohibition on free speech zones, we also have these special state laws. Group recognition. These sorts of cases we often see regularly, and they involve either student governments or the administration refusing to recognize a student group because of their beliefs. As I mentioned before, Fordham University refused to recognize the Students for Justice in Palestine chapter because of its views. That case was taken to the courts and New York State courts, and the university was held to be in violation of their contractual promises. Another case we got involved in involved this young lady at Truman State who wanted to start an animal rights group on campus. Truman State is in Iowa. Iowa is a big cattle state. It has a lot of factory farming. It has a lot of special interests that don't love the animal rights cause, or PETA, which the student group would have been associated with. And so the student group was denied, predicated on the, quote, emotional risks that the student club members might encounter from hostile responses from those opposed to their view, as well as, quote, the reputational risks to the university and the students posed by affiliating with PETA. We got involved in that case, and thankfully were able to get the student group recognized. Another case, political speech. Every election season, we see colleges and universities saying that students can't engage in political activism or political speech on their campuses because it would violate the college or university's nonprofit status. This is not true. The IRS has issued a special memorandum saying this is not true. And we've even had testimony in Congress explaining the problem to the Congress about these colleges and universities that say that students can't engage in political activism or speech because the universities are arguing that it violates their nonprofit status. This picture is from a case we had at Georgetown, where a group of Bernie Sanders supporters were tabling in support of Bernie Sanders. The university there said, you can't table, it violates our nonprofit status. We ended up winning that case, and Alex Atkins, who is this gentleman on the far left, ended up testifying in Congress about the threats to freedom of speech posed by universities using their nonprofit status to throttle political expression. Alex went on to become a fire intern after his experience. Student press. We often see newspapers stolen by angry campus groups or individuals who don't like coverage of them or their group in the student newspaper. They'll take the stack of newspapers and throw it in the trash. This is not legal. This is vandalism. This is theft. And those who do it can be criminally charged, in fact. We also often see advisors, faculty advisors, punished or threatened by their administrations for critical coverage of the administration by student newspapers. One of the very common cases that we see at FIRE involves overbroad or vague harassment policies. Harassment is not protected by the First Amendment, but just because you call speech harassment does not mean it meets the Supreme Court's definition of harassment. Harassment must be speech or conduct that is so severe, pervasive, and objectively offensive that it effectually denies students the right to an education. This was held in the 1999 Supreme Court case, Davis v. Monroe County. And one example of a university misusing a harassment standard came in our 2007 case involving Keith John Sampson at IUPUI, that is Indiana University, Purdue University, Indianapolis. Keith was a non-traditional student, an older student who was working his way through college, and during his lunch break was reading this book on the right, Notre Dame versus the Klan. As you can see, it has depictions of cross burnings and of Klan members on the front, but it is a book about the defeat of the Klan when they marched on Notre Dame's campus in the 1920s. Someone else had walked by Mr. Sampson reading that book, I think in some sort of lounge area of a campus building, filed a complaint, and Keith John Sampson was brought up on charges of racial harassment merely for reading a book, and for someone else merely judging a book based on its cover. I should note that this book was found in the university's library itself. We wrote a letter to the university, eventually had to take the case public, and it quickly backed down after an op-ed in the Wall Street Journal. One of the more troubling trends we're seeing on campuses across the country, although it's waned a bit since 2017, is mob violence. These are individuals using some sort of violence in opposition to speakers they might not like in an attempt to shut down those speakers. We saw it most prominently at Berkeley in 2017 when Milo Yiannopoulos was set to speak on that campus, causing something like $500,000 of damage. There were Molotov cocktails thrown. There were individuals sent to the hospital. It was a not too great scene. I remember it quite vividly because it occurred on my birthday in 2017, and I remember having to throttle my birthday plans in order to work with fire to issue a statement about the event. There are more ways in which speech is threatened on campus. There are other ways of administrative overreach. There are unconstitutional security fees that burden controversial speech. And if you have any questions about these cases or others that you might know of, I'm happy to address those in the Q&A segment. One thing that you'll often see is that when you're fighting censorship is that people will always try and find justifications for censorship. They'll find their own but. National security, offense, the idea of domestic tranquility. But often these buts don't actually fit within an exception to the free speech clause of the First Amendment. And one of the most common buts you'll hear comes from Schenck v. United States. You're probably familiar with the phrase shouting fire in a crowded theater. That phrase often omits falsely shouting fire in a crowded theater and also often admits the context. So this case, Schenck v. United States from 1919, involved a group of Yiddish-speaking socialists in Philadelphia who were pamphleteering against World War I. They were arrested, and their case went to the Supreme Court, where Justice Oliver Wendell Holmes said that the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. So what Schenck was saying there, or what the court was saying there, was that protesting a war and handing out pamphlets was akin to shouting fire in a crowded theater. I would argue that during World War I, there was a very crowded theater in Europe, and we probably needed someone to shout fire. And these Yiddish-speaking socialists in Philadelphia were doing precisely that. But I should add that this is no longer good law, and that Oliver Wendell Holmes himself repudiated in subsequent cases. However, you often, when you do First Amendment work, see you can't falsely shout fire in a crowded theater trotted out as a justification for censoring a wide swath of speech, and that falsely word is often omitted. I want to talk about America kind of being alone next. It's important that we recognize that America is pretty much alone in the breadth of expression that it protects. We have the fewest, quote, buts. And in a moment, I'll argue that that's for good reason. There are a lot of other countries that go after speech that would be protected in the United States. I like to quote Jon Stewart here. He says, if you don't stick to your values when they're being tested, they're not values, they're hobbies. And weighing whether a principle is a true principle or a hobby, I think can be in large part determined by the number of exceptions or buts we make to that principle. America, unlike other countries, doesn't make a lot of exceptions. A lot of other countries, for example, ban hate speech. Germany punishes anyone found guilty of insulting or defaming segments of the population. In the United States, you're perfectly free to insult segments of the population. The Netherlands bans anything that verbally or in writing or image deliberately offends a group of people because of their race, their religion, or their beliefs. You can offend people because of their beliefs or because of their religion in the United States. Romania forbids possession of xenophobic symbols. The United States, you can possess xenophobic symbols. Poland actually recently passed a law criminalizing discussion of Polish complicity in the Holocaust and the use of the phrase Polish death camp. I think they've subsequently rolled that back, but the idea being there that to protect our national reputation, you can't say that any of these death camps were Polish. That would never fly in the United States based on our Constitution. So, as I kind of tipped my hat to earlier in the conversation, why do we defend offensive, hateful, and even wrong-headed speech? A lot of people say because we have a First Amendment, but as I argue, that's a circular argument. Why do we have the First Amendment in the first place. So in this final part of the conversation here, I want to go through some of the philosophical justifications for free speech, and therefore the philosophical justifications for the free speech clause of the First Amendment. The first is it's important to know the world as it is. It's important to know what people believe, not only when you disagree with what they have to say, but especially when you disagree with what they have to say. You don't change people's minds by shutting them up. You change their minds by convincing them that your ideas are better. In that sense, censorship is like breaking a thermometer. Just because you've broken the signal that tells you what temperature it is, doesn't mean the chill has gone away. We also want to know, as one of my colleagues, or the Fire's co-founder, Harvey Silverglate, once said, he's a Jewish man. He said, I want to know who the Nazi in the room is, so I know not to turn my back to them. So it's important to know the world as it is. Censorship is also just plain bad tactics. So I mentioned the mob violence that occurred in Berkeley in 2017. After that happened, Milo Yiannopoulos, who, if he was allowed to speak at Berkeley, would have probably spoke to 100, 200 people, ended up spending the entire night on national television, and his book went to #1 on the Amazon bestsellers list. So it's bad tactics. This is called the Streisand effect. Barbara Streisand, many years ago, had a house in Malibu on the beach, and as part of some online geological program that was charting the ocean front in California and the erosion of it, her home appeared. She tried to get it censored within that program, and you guessed it, her home became much more popular than it otherwise would have had it just been allowed to be on that program. So you censor the people you don't like, you end up creating a greater platform for their message and turning them into martyrs. Another reason it's important to defend free expression is because it helps us sharpen our ideas. Knowledge is like a muscle that needs to be exercised in order to remain strong. We need to have our values and our ideas challenged to keep them alive. I often like to tell students to think about summer breaks. You forget a lot of what you learn because you're not exercising those muscles. I think John Stuart Mill, who wrote probably the best treatise on freedom of expression ever written back in 1859, which was quite the year for philosophical and scientific treatise, because that's also the year that On the Origin of Speeches was written. But he wrote that both teachers and learners go to sleep at their post as soon as there is no enemy in the field. And this, to me, is especially important on college campus. This is where we go and spend a lot of money to sharpen ideas. So, how do we sharpen our ideas? There might be something that, and I would argue, and John Stuart Mill argued, there might be something that we can learn from what we think are wrong-headed ideas. On the one hand, the idea might be right, and we trade falsity for truth. On the other hand, the idea might be wrong. We might not change our minds in those cases, but we create a greater conception of the truth, a more nuanced understanding of an issue, and we become more prepared when our position, whatever it is attacked. I like to cite the idea of flat Earth and evolution. A lot of us take these sorts of, take the idea that the Earth is round and that evolution exists for granted. And some people might, including myself, not have the arguments at the ready if I'm ever confronted with a flat earther or a creationist. And the reason I might not have those arguments at the ready is because I'm not often sharpening those arguments, because they're not often challenged. John Stuart Mill talked of the fatal tendency of mankind to leave off thinking about a thing when it is no longer doubtful. He says this is the cause of half of humanity's errors. He said it's the deep slumber of a decided opinion. So the advancement of unchallenged dogmatic beliefs should scare, I'd say, the heck out of any intellectual, any scholar, and censorship encourages ideas to go unchallenged. I'd also say that censorship is an arrogant assumption of infallibility. To refuse, as John Stuart Mill said, adhering to an opinion because you are so sure that it is false is to assume that your certainty is the same thing as absolute certainty. When we're talking about freedom of speech, we often think about the speaker, but we should also consider the listener. Back in 1860, Frederick Douglass, the great abolitionist, wrote a plea for free speech in Boston. And he wrote this because at the time he was organizing abolitionist meetings in Boston. And one of those meetings was shut down by an angry mob that didn't like the message of the abolitionist congregation. And so he wrote this plea for free speech in Boston, which he said to suppress free speech is a double wrong. It violates the rights of the hearer as well as those of the speaker bearing witness to one's beliefs, the idea of individual autonomy, the listener who might learn something from the different beliefs or the beliefs expressed by the speaker. Another justification for free speech is that censorship is a blunt tool, and I would say not a civilized tool. In this world, we have two ways of influencing people. We have words and we have violence. What distinguishes liberal societies, I would argue, from illiberal societies is that in liberal societies, we use words, not the blunt tool of coercive violence or censorship to overcome differences. Censorship in reality just short circuits arguments and does a disservice to our own intellectual development and an understanding of the world as it is. Now, Sigmund Freud, love him or hate him, once said that civilization began the first time an angry person cast a word instead of a rock, which I think gets to the heart of the matter. So, in short, freedom of speech gives a voice to the voiceless. It puts the power in the hands of the individual, not the government. And in the context of college and university campuses, public colleges and university campuses, the government is the administration. After all, what government official would you entrust with the power to determine for you, the listeners, what books you can read, for you, what movies you can watch, what speeches you can attend, for you, what ideas you can hear? I don't think there's anybody I would entrust with that power, and therefore with the power of censorship. If we give the power of censorship to the government, which of these two men or two past presidents would you trust with the power to censor? Because censorship, or giving someone the power to censor, presumes that there is such a person with whom you would entrust that authority, and that they and their successors, and there will be successors because we're all mortal, none of us are angels, that they and their successors will wield this power wisely. The right to freedom of speech presumes that nobody should hold such a power in a democracy. So I'm right on 45 minutes on the dot, or 46 minutes, I should say. So I think I will close it up there and encourage you all, if you're interested in learning about the work that FIRE does, by visiting our website. You can go to thefire.org. There you can find many of our resources for students, faculty, and administrators, and a couple of plugs for some of the books and movies that we put out. My boss, Greg Lukianoff, the CEO and president of FIRE, he's written two great books on freedom of speech on college campus, including the 2012 book on learning liberty, and then the 2018 book, The Coddling of the American Mind, which became a New York Times bestseller and was on the New York Times bestseller list for, I think, a total of 9 weeks. I also host a podcast, as Jeff pointed out, called So to Speak, the Free Speech Podcast. I've been doing it for every other week for 4.5 years, and you can find it wherever you get your podcasts. We look into various free speech topics. It's not just focused on college campuses. The goal is to educate the public on freedom of speech. Next week, I'm interviewing this man, Richard Ovenden, about his book, Burning the Books, which is about the deliberate destruction of knowledge, including book burnings, which should be fascinating. And then the aforementioned movie I created, Mighty Ira, about the life and career of former ACLU executive director and FIRE advisory council member, Ira Glasser. You can watch that for free on Amazon Prime. And if you do, and you like the movie, please rate it or review it on Amazon or IMDb. I would appreciate it. So I think it's with that I will open it up to questions. I'm happy to do my best to answer all the questions that I can.
Thank you, Nico. This has been great. I'm going to take a sponsor's prerogative by ask the first question.
Of course.
And let me tell you that college campus, we definitely have been struggling with, many of the things you talked about, the balance of harassment versus hate speech. Where does that go? How do you write a policy that, fits Title IX definitions and state definitions and the First Amendment itself. We definitely have struggled with the heckler's veto. Not here as much, but in my previous institution, we definitely had trouble with that. And I think one of the things that I hear constantly from the students now is, the words do hurt, and please protect us from those hurtful words. And it's not coming from the administration anymore, it's coming from the students. And I wonder if, just as fighting words fell out of favor as generations shift, do you think it's possible that fighting words might come back?
Well, that's definitely a concern, because the Supreme Court and the judges who sit on various lower level courts are people too, and they're often informed by their experiences in college or university. And while the courts are very good right now, in Fire's opinion, on these matters, a different generation that brings different values to the law might change the law. As Learned Hand famously said in his Spirit of Liberty speech in 1944, I believe, in Central Park, that the spirit of liberty lies in the hearts of men and women. And when it dies there, there's no document in the world, even the Constitution, that can save it. I want to speak to the first, to kind of your prefatory clause there about the difficult spots that college administrators and faculty members are in. We at Fire definitely understand this. You have various interests at play. You have parents, you have asking for one thing, you have students asking for another thing, you have various laws, you have state legislators to work with, and you have special interest groups like Fire that cares about a narrow segment of the Constitution to contend with. So you're often in a rock and a hard place, and you're often in dealing with a shifting policy landscape that changes with administrations. We don't know, we know what Title IX was under the Obama administration and how they interpreted it and the pressures they brought to colleges and universities. That changed under the Trump administration. That will probably change by all indications under the Biden administration. So I do not envy the position you all are in, and I understand it. But getting back to your point about how to address the student concerns, my boss, Greg Lukianoff, in his book, Coddling the American Mind, spoke to that precise concern that you're discussing. We call it the medicalization of censorship, the idea that we don't just disagree with things, but it creates an internal trauma and stress that has physiological effects even. And there's no, how do you dismiss someone's subjective feelings? It's very difficult to do. And Fire for a long time has operated under what we call the strong student model, that there is nobody who's too weak to live with freedom. That is to say, nobody too weak to live with freedom of speech. And we seek to remind students that while speech might be uncomfortable, it can serve as a learning opportunity as well, and that censorship, for all the reasons that I just went through, is a short-sighted approach to speech that we might find uncomfortable or offensive. Ira Glasser, the subject of Mighty Ira, says censorship is like poison gas. It might be great when the enemy is in your sights and the wind is at your back, but the wind has a tendency to shift. And Ira learned about this when he was defending civil rights marchers in the South in the 1960s. The civil rights, the local communities used to pass insurance bond requirements to prevent marchers from marching there. And then, it was used against the Nazis in Skokie, but that can be used to censor all sorts of different speakers. So you don't want to give that power to government. So I think I'll just leave it there.
Yeah, I tell my students all the time, like the same thing that is protecting, like the Bible believers on our campus also protect Black Lives Matter. And when I was a college student, it protected the LGBT groups, and it protected, so there definitely is a shifting policy that I love that, the winds can shift.
It's an insurance policy. Freedom of speech is an insurance policy for your viewpoint. And there's no social justice movement in America that didn't depend on the right to speak out. and it didn't require it to advance. John Lewis, the late great John Lewis, once said that without freedom of speech, the civil rights movement would have been a bird without wings. They depended on the protections of that the First Amendment provided to get their civil rights message out to the public. And if the Southern governors had their way, they would have been censored. But the First Amendment stood in the way, thankfully.
Yeah, great. We did get a question in the Q&A. So I do want to mention that if anyone wants to use the Q&A feature, they can. If you want me to turn on your mic, you can use the raise hand feature. But I will ask from an anonymous attendee, how does free speech play out in a classroom setting? Does a college faculty member have the right to control speech in the classroom or control the classroom itself? That could maybe, I'm adding this, that wasn't part of the question, but maybe chill free speech?
Yeah, so the short answer is yes. So faculty members have the academic freedom right and the pedagogical interest to control their classrooms as they see fit, with certain narrow caveats. The faculty members shouldn't be docking students their grade based on political viewpoints they might disagree with. They to the extent they're enforcing policies that they have within their classroom, they need to be enforced in a fair, even-handed, and non-viewpoint discriminatory way. But the long and the short of it is that yes, they have the right to control the speech within their classroom within reason. If there is a student who is speaking and there are other students who continue to interrupt that speaker, then the faculty member certainly has the right to address that disruptor in the classroom. Again, where you get into trouble is when you start applying policies that do not exist, and start applying policies that do exist in a discriminatory manner.
Yeah. So similar to like an administrator like myself who might have time, place restrictions, like no amplified sound next to a classroom, no matter what your message is. A faculty member has to have kind of fair, equal, speaking rights within the classroom.
Correct. Yeah.
Excellent. Again, I'm going to ask if anyone has any questions. Go ahead and throw them in the question and answer, or use the raise hand feature. I don't see any raised hands. So,
and I should say, just to piggyback on that, while we're waiting for potentially more questions, is that a case we often see as well is when administrators interfere with the classroom work of faculty members, their academic freedom rights and their pedagogical rights to teach the classrooms as they see fit, when they get involved in what they are supposed to teach or dictating their curriculum. That's really the prerogative, or should be the prerogative, of faculty members and their departments, not of non-academic administrators.
Yeah, excellent. I'll bring something up here that also came up at our campus. We actually have a question, so I'll defer to that one, and then I'll ask mine in a minute. Hit the button here. Hello, we have a Craig on the line. Craig, do you have a question you'd like to ask?
Yeah, can you hear me?
Yes, we can.
Sure can.
Yeah, Nico, actually goes back to the visit from the Bible believers, because in our procedures on campus, we talk about time, place, and manner, which you mentioned. But when the Bible believers arrived, they looked at the location that we established and said, this won't do. Now, we convinced them that that location would do. But my question is, so where do you draw the line on time, place, and manner if a group does not like the arrangement you've made for them?
Yeah. So there are a couple of considerations there. Let me start with, so Bible Believers, I'm assuming, is an off-campus group, not a Bible Believers student chapter, correct?
Correct.
Yeah. And these sort of speakers were they've been on campus for decades. They were on campus when I was in college. So students and student organizations, those who are associated with the university, have greater First Amendment protections at those universities than off-campus groups. That said, at public, college, and university, so if you're involved in using a student group, you can't just segment them to a free speech zone. There was a court that held that to the extent that public college or university has sidewalks, it has public areas of campus that do not, and the speakers aren't seeking to prevent, access to buildings and stuff like that, that the speech needs to be allowed to occur in those environments. It can't it can't go occupy a building, things like that. But off-campus speakers, the college and university does have a little bit more discretion in how it can determine where these individuals can engage in their expressive activity. So without knowing the specific facts of it, I would say that so long as you aren't cabining them to one area that's like very out of the way and wouldn't allow them to share their message with anyone else on campus, but you're giving them maybe a couple of areas and you're trying to accommodate the message, then you can kind of determine the areas where you'd prefer these off-campus speakers to speak. And I should say that the law, so far as I'm aware, isn't super clear on this, but the law does give more discretion to college and universities involving off-campus speakers than it does on-campus speakers. That is to say, people not affiliated with the university versus those who are affiliated with the university.
Yeah. That's great, because that's actually the same mechanism we use for, the heckler's veto.
Mm-hmm.
If you reserve the room, you have more rights to speak than the person who is shouting, who has not reserved the room. And we frequently ask people, okay, now that we've heard you, please respect the speaker's time to speak. Great, throw that sign up. Do whatever you want to do, but at some point we do need to hear the speaker, because they have reserved the room and that organization has put forth this speaker. So
yeah, we see those sorts of cases all the time involving someone bringing a speaker to campus. Maybe it's a student group, maybe it's the administration, and then other students who do not like the message of that speaker essentially occupying the room. It's fire's position that fleeting chance or maybe holding up a sign for a short period of time is fine, but if the disruption materially disrupts the private event, essentially, then that's not protected speech. And fire would argue it's actually the duty of the administration to ensure that the event can go off as the event organizers intended it to go off. Otherwise we get into the sort of situation that Frederick Douglass got into in Boston in 1860, where anti-abolitionist speakers prevented his meeting from occurring. And he wrote that first great essay on the heckler's veto.
Yeah. And you mentioned the Milo Yiannopoulos case on campus. That is definitely like the fear of every college administrator on, not that Milo comes, that some so unpopular speaker comes on campus that it causes violence, a violent reaction.
Yeah. And we definitely understand the tough position that college administrators are in those cases. And kind of the law kind of requires colleges and universities to do everything they can within reason to ensure that violence doesn't happen and the speech is able to go off. But if they've exhausted all mechanisms at their disposal, then in those very narrow cases, can the college or university or any government shut down the speech. The heckler's veto actually is it's used colloquially as a kind of a cultural phrase, but it also has a specific legal definition, which involves when governments shut down speech in the anticipation of violence or a heckler. That's prohibited, and it's actually the Bible believers case that kind of created that standard.
Oh, excellent. I was not aware. Great. Craig, anything else to say before I mute your mic?
Oh, good. Thank you.
Thank you.
That.
All right. If there is any other questions and answers questions out there, I'll take them now. If not, I'll go ahead and ask one more, and then we could probably wrap it up. One of the things that I know that is also struggled with on a lot of different college campuses, and is the newfound, I guess, battle cry of the conservative movement that, this is free speech and you are causing my free speech to be to be, you're infringing on my free speech rights because you took me off Facebook, or you took me off a commercial platform that is not a government. And there's people who are making arguments that these incredibly powerful online platforms, like, I assume an email or Facebook or Twitter, have become the town square. What's happening in this world?
Yeah, I've seen those arguments quite frequently, and so just kind of a couple of first principles here. These are private companies, not bound by the First Amendment. They can set their terms of service. They can allow whatever speech they want on their platform and censor whatever speech they don't want on their platform, so long as they're abiding by their terms of service. Now, what they're legally supposed to do, or allowed to do, I should say, is different from what I think they should do. I work with Facebook all the time because I work for an organization that tries to advertise on Facebook and tries to share a message on Facebook. And what I found there is that their policies are so vague, overbroad, and inconsistently applied that no one has any idea what they're allowed to say on Facebook. And that once you start censoring speech, like, for example, they said recently that they were going to censor Holocaust denial speech on Facebook. As soon as that happened, other groups started to get what we call at Fire censorship envy. Well, you're censoring the Holocaust deniers. Why aren't you censoring those that denied the Armenian genocide, or this, that, or the other?
Interesting.
Cause?
It's very interesting. Yeah.
Yeah. This, that, or the other cause that is near and dear to our hearts. So as soon as you open the door to viewpoint censorship, everyone thinks that their viewpoint that they hate should be censored. And you're starting to see that with Facebook. And so they write these vague, overbroad policies that sweep within their ambit almost any speech. You say something's hateful, that could be anything. You say something's offensive, that could be anything. So, and we've told this to Facebook. They've reached out to us and consulted. We said, and they're between a rock and a hard place too, because they're a global platform subject to a lot of the laws of other countries, not just the First Amendment standards of the United States, but yeah, so you can start your own company. I know that's not easy because you need the network effect in order for it to be effective, but they have the right to do it. Whether it's a good idea, I would say it's probably not.
Yeah,
it's another thing entirely.
Yeah, and I actually forgot to bring it back to a college campus. What we're seeing on college campus is, typically a conservative group will say, well, because this is a voter registration table, you can't ask me to move it off the path, or
yeah, no, you can do that. To the extent that you're trying to allow for egress or foot traffic, you can move it off the path. And so the standard is that the requests have to be reasonable, and that the government must do everything within its power to accommodate the speech that it can. So in this case, asking someone to move their table off of a sidewalk and into the adjacent grassy area, still within view and within talking distance of passerby, is totally allowed.
Yeah, it's a new phenomenon we've seen, that like they try and say, well, it's a government free speech item, so I don't have to do any of your requirements. It's interesting.
Yeah, if you or any of your colleagues ever has any questions about those sorts of things, just give us a call or shoot us an email. We can answer. We're happy to give our opinion, and we can usually answer within 24 hours.
Yeah. Excellent.
And I should add that my email address is nico@thefire.org. So anyone who has any future questions or wants to get in touch, please do just shoot me an email, and I'm happy to if I can't answer it, direct it to my colleague who can.
Yeah, excellent. I'm going to just open up one more time, and then we're going to wrap it up, because this has been fantastic. I'm very excited. I'm glad for all the people who showed up. I'm glad for the questions. And I don't see a hand, or I don't see a question in the Q&A. I'm going to say thank you for coming.
Yeah, well, I appreciate you for inviting me, Jeff.
All right, we're getting lots of thanks and fantastics in the comment feed. So. Excellent. I'm going to push stop on the recording. Let's see here.